So let me welcome you all to this first talk in this year to the webinar of the joint webinar of ESL and ASL, the interest groups of international law and social science. And we have a fantastic topic, which is compensation, economic hostages, and market access, lump sum agreements since Westphalia. I think that's highly topical, given the ever more transactional nature of international relations. I do not necessarily mean this positively. I'm Anne van Aaken, Professor of Law and Economics, Legal Theory, Public International Law and European Law at the University of Hamburg, and the co-vice chair of the ASL Interest Group on International Law and Social Sciences. We have a lineup of fantastic speakers, so I briefly introduce them. We'll start with Lauge Poulsen, who is professor and deputy head of the Department of Political Science at the University College London. He works on the politics and law of international economic relations, and I think by now is famous, even though he's a political scientist, among international lawyers as well for all his excellent empirical work closely connected to international law, and one example we will have today. Since 2021, Lauge has been chair of the OECD Intergovernmental Work Program on Climate Change and Investment Law. Join the OECD conferences if you can, they're always great. Previously, he served as a specialist advisor to the International Trade Commission in the House of Commons in the UK, and was advisor to the Foreign and Commonwealth Office from 2017 to 2020. In 2022, he was also appointed Officer of the British Empire. I'm not quite sure what exactly that means, but it looks very honorable, for services to the UK trade policy. Before joining UCL, Lauge was a postdoctoral fellow at Nuffield College of the University of Oxford, and he has been a visiting scholar at the Brookings Institution, Melbourne, and the Melbourne Law School. He's on the editorial boards of the Journal of International Economic Law, the Journal of International Dispute Settlement, and the World Trade Review. Let me now turn to the discussants. We are very happy to have great discussants for that matter as well. Let me turn to Geraldo Vidigal, who is Associate Professor at the University of Amsterdam. He's co-chair of the Free, Fair and Green, Governing Europe's Trade Relations in a Changing Global Economic Order research project of the Amsterdam Center for European Studies, and Managing Director of Legal Issues of Economic Integration. He publishes regularly on international economic law and international dispute settlement, and currently he focuses on the transformation of international economic law in response to pressures for it to balance the protection offered to the interests of transnational economic agents with sustainable development. On dispute settlement, and here I'm making a bit of marketing, he's currently finalizing a book entitled After Adjudication, Judicial Remedies for Non-Compliance in International Law, which is going to be out with Cambridge University Press in this year. We all know that academics are nomads, but Geraldo has seen it really all. He has a PhD in law from the University of Cambridge, a master in international law from Sorbonne, a Bachelor of Law from the University of Sao Paulo. And he had several fellowships at the European University Institute, Bocconi, the Graduate Institute in Geneva, in Berlin, as well as the Max Planck in Luxembourg. And last but not least, he was a lawyer at the WTO. So he has really been everywhere. Now, Joost is someone I probably wouldn't even need to introduce, certainly not for anyone who's doing international economic law. I nevertheless do that. And I have to say, I mean, all your CVs are so big and broad and so many accomplishments that I couldn't do it all. He's professor of international law at the Graduate Institute in Geneva, and co-director of the Institute Center for Trade and Economic Integration. He's also visiting professor of law at Georgetown University since 2014. And previously, he was a professor of law at Duke University. He also taught at Neuchâtel in Switzerland, Columbia, NYU, Stanford, and Harvard law schools, and worked as a legal advisor for the WTO Secretariat. He was also a senior advisor with the law firm King & Spalding. He specializes in international economic law, particularly trade and investment, as well as its relationship to public international law. He also frequently advises governments and industry in WTO dispute settlements and investment arbitration. And I really would like to mention that is the leading force behind the Global Trade Lab, which most of you will know, which is a great project of bringing trade law to the people who need it, and also as a student training center. So it's a legal clinic on international economic. Joost was the co-editor-in-chief of the Journal of International Economic Law, and he is also he was appointed, nominated by the EU to the WTO's multi-party interim appeal arrangement, MPIA, which most of you will know. He received his degrees from the University of Namur and Leuven, and as well as Oxford University, and holds a doctorate from the University of Neuchâtel. This is it. I stop here. I don't mention all the other great things you have done. And I hand over immediately to Lauge. We are much looking forward. No, there's one thing I still need to say. This is very important for the audience. So Lauge will speak about 20 to 25 minutes. Joost and Geraldo each 5 to 7 minutes, everyone. And then I would like to really have space for questions and answers and the discussion. So please put your questions in the question and answer box function, and I'll monitor them there, Lauge as well, and then we hope we can answer all of them. Thanks a lot.
Thank you so much, Anna. I just want to check you can see my slides here on the screen.
Yes.
Yes, great. Excellent. Thank you for that kind introduction. And thanks to those of you who are listening in, and thanks also in particular to Geraldo and Joost, who have agreed to flog me publicly today for my working paper on lump sum agreements. And the starting point, I think, for any presentation should be, why should we care about this particular topic? And I think maybe on lump sum agreements, many would ask that question in particular. And I think there's sort of a couple of reasons. And Anna, in a sense, already outlined, I think the important one in the context of current international claims settlement, and that is that lump sum agreements were the result of pragmatic, political, and as Anne put it, transactional considerations between states to settle a wide range of international claims. And they were often, not always, but often seen as alternatives to adjudication, either because there were no avenues available for adjudication, or because the avenues that were available were not seen as appropriate or acceptable. And so in broad strokes, the agreements were seen as sort of alternatives to more legalized or adjudicated forms of dispute settlement or claim settlement. And in the context of modern day claim settlement, that's of course interesting given some of the concerns, some are referred to as the backlash against international courts and tribunals in the context of certain types of claims, particularly in the context of property claims. The second reason, I think, is because, as we shall see, one of the arguments that I'm trying to make in the paper is that when we look at how lump sum agreements were negotiated, they were often negotiated on the back of frozen assets. And they were often negotiated in the context of sort of managed trade, where import and export relations were managed by both governments and became part of a broader diplomatic bargaining chip for claim settlement. And sort of given the transactionalism that Anne referred to, I think that's also relevant for today, and maybe what is to come in claim settlement over the coming years. The starting point for the paper was actually another project I finished a couple of years ago with Eileen Denzer, that was published in the American Journal in 2023. And I thought I'll just start there because that is sort of a natural starting point for the project. We traced the negotiations of a set of lump sum agreements negotiated between the Soviet Union and the United Kingdom involving the Russian Revolution claims. As everyone knows, the Russian Revolution resulted in large-scale expropriation and default on the Tsar's debts. And as a result, holders of Tsar's debts and assets inside of Russia up through the 20th century asked for compensation in various fora, but of course there weren't any international courts or tribunals to hear those claims, and so this became a diplomatic issue between Western governments and the Soviet Union. And in the case of the United Kingdom, there was in fact a settlement that ultimately came in 1986, and that settlement resulted in some payment to the few survivors, but typically this would be children or grandchildren of claimants from the Russian Revolution. But most of the private claims were ultimately not paid. This was a sort of a relatively small amount of money we were talking about, and given the context of the amount of claims in question. However, the reason that the UK government's legal advisors agreed that this was nevertheless justified was because there are counterclaims from the Russian government going back to the Russian Revolution, where British forces stayed back in the Russian Civil War in a way that was illegal, and which the UK legal advisors, first in 1924 and later in the 1970s to the UK government, agreed were illegal. And those claims were legitimate. And as a result, when settling all the Russian Revolution claims in the 1980s, they had to enter into a crude balancing exercise between the claims of bondholders and investors on the one hand, and then the claims of the Russian government against the UK on the other. And the reason I mention this is because I think the context for those settlements is sort of foreshadows many of the conclusions in this working paper. First of all, the payments that were made and the compensation that were issued in this particular settlement came from frozen assets that have been standing in British bank accounts since the revolution. And in this paper, I refer to frozen assets as hostages, and I'll get back to that in a second. Secondly, market access or trade issues were also critical, at least in a broad sense, because the reason Gorbachev agreed to settle in the first place was because he needed access to the city to raise bonds in order to fund perestroika. So he needed access to the city of London, but he was blocked from that access because of the Tsar's debt disputes. And one of the things I find in this working paper is when taking a much broader view over the history of lump sum agreements, we find that those two mechanisms, or those two variables, if you will, of taking hostages, say freezing assets in exchange for compensation on the one hand, and managed trade or market access on the other hand, have been quite important for a very large number of lump sum agreement negotiations. Descriptively, what the paper does is to compile what is today, I think that, well, it is the largest amount of lump sum agreements that have been compiled to date, going back all the way to well, just after Westphalia. And to get a descriptive overview of the use of lump sum agreements for claims settlement. And most importantly, the agreements became key in the 20th century for a wide range of claims, in particular for property claims after socialist revolutions and expropriations. But the agreements have been used for well, since essentially the beginning of sort of the modern era, and have been used to settle a very wide range of types of claims, and were by far the most important instrument for claims settlement in the 20th century. And that, I think, is often overlooked or glossed over in modern scholarship on international claims. And one of the reasons, I think, is because when we look at the repayments that were enshrined in lump sum agreements, it was often partial. There were rarely full compensation. It could happen on occasion. This can be difficult to estimate, but where we can estimate the amount of compensation that was enshrined in lump sum agreements, we typically found that there were limited and often partial compensation, but quite significant variation. And I go through some of that in the paper and I don't have time to go into that in detail. But I think there's been a sense in which the agreements, because of the limited compensation they often resulted in, should be seen as perhaps lesser instruments of dispute settlement than more adjudicative forms. Now, in terms of how they were negotiated, I think there were two basic dynamics that were particularly important, and I've already alluded to them in the context of the UK-Russia settlement. The first was for the home state to take an asset, a hostage, until compensation was paid for claims. And this has been a pattern going all the way back to some of the first lump sum agreements. So, for instance, I highlight lump sum agreements going back to the 17th century where maritime claims were settled as a result of sovereigns taking hostages, in this case ships, until compensation was paid out. And that was one way in which governments would try and resolve maritime disputes. They would take ships hostage until proper compensation was paid for maritime claims in cases where there was no proper recourse through admiralty courts. And we see that pattern of taking hostages, freezing assets in different forms, repeating itself time and again when we look through the negotiation of lump sum agreements over time. So here we have selected US lump sum agreements, and we see the amount of compensation in the agreements on the right-hand side. And then we see the release of frozen assets on the left-hand side. And for the US government, this was a sort of a core strategy to withhold frozen assets until claims were being settled. And then once the claims were settled and paid, you release the assets. And so sort of conceptually, the negotiation and conclusion of lump sum agreements can be seen as sort of something akin to a hostage exchange. That's the first dynamic. The second dynamic is, as I alluded to in the context of the UK-Russia claims, the role of market access. And again, this goes all the way back to some of the very first lump sum agreements that at least I have been able to trace through various sources. So for instance, and again, the Netherlands was important here, you had a series of claim settlements and lump sum agreements that were negotiated where compensation was paid in exchange for greater market access, in this case to the home state. So here we have one of the very first lump sum agreements between Sweden and the Netherlands, and Sweden agreed to pay compensation and enshrine that in a lump sum agreement, but only after the Netherlands agreed to open its markets for Swedish vessels. And as a further link between trade and compensation in this case, and we shall see that was also not unique, compensation in the agreement was to be paid partially through revenue coming from trade. And again, if you go up, take a sort of a broad view of the negotiation of these agreements, we see this time and again. A particularly interesting example is the case of Japan, who entered into a series of lump sum agreements during the 1950s and 60s. And the way that Japan negotiated the agreement was to essentially pay compensation through the provision of Japanese goods and services. And this was explicitly framed by Japanese officials as a way to gain a foothold in Southeast Asian markets, particularly for sort of in the context of construction and related sectors. So for instance, Japanese diplomats would quite openly tell their counterparts that the aim with settling many of the claims for Japanese measures during the Second World War and doing it through the provision of goods and services was in order to get a foothold back into those markets where Japan had previously been kicked out from as a result of the war. And we see the link between lump sum settlements and lump sum agreements and managed trade in other contexts as well, and it operates in different ways. Here we have a table a little bit difficult to dissect, so I'll walk you through it. We have a series of agreements negotiated between Western European states and socialist states or Eastern European states, Bulgaria, Czechoslovakia, Poland, and Romania. The brackets is the year of the lump sum agreement, and we see that a number of those agreements were very explicit about linking compensation for claims to export earnings. So there was a very direct link between trade and compensation. In other cases, as in the case of Japan, the compensation was paid through goods such as coal. And in yet other cases, you had a very clear link between negotiation of compensation on the one hand in a lump sum agreement, and then a trade negotiation that would often be concluded around the same time. So again, the dynamics were different in each case, but the link between managed trade and compensation, I think, is a key feature that has sort of played out in the negotiation of lump sum agreements for hundreds of years. Now, of course, something has changed over the last couple of decades in how we settle international property claims. And most important here has been the sort of rise of investment treaty arbitration. And one of the implications I try to sort of raise in the paper is in terms of the amount of compensation that's been issued by handing over these sorts of claims to arbitrators rather than having them negotiated between home and home states through sort of transactional bargaining. And when we look at the compensation that were issued in property claims and other types of claims up through the Cold War in lump sum agreements, it amounted to something like 40 billion in constant dollars, about 80 billion if you include non-property claims. And that was very quickly dwarfed, of course, once investment treaty arbitration started taking off, as you can see in this slide. And so I think there's sort of three, I've called them provocations, but there are three questions, at least to me, that the paper raises. The first question is ultimately a question of economics. And what you often hear when we sort of discuss politicized, if you will, settlement of investment disputes is a notion that it's bad economics, right? That because we see partial and in some cases negligible compensation to private claimants, that's ultimately bad economics. But when we take a slightly broader view, in particular consider trading interests, I think the view of many home states up through the Cold War, for instance, was that prioritizing expropriated investors or bondholders over trading links with partner states would have been bad economics. And so I think there's a question or provocation there. A second question relates to politics, and that is whether and to what extent home state involvement in the resolution of claims is necessarily a bad thing. We often hear it is, and in many cases I would agree with that. But in some cases, you do see in the context of lump sum agreements examples where the interest of foreign investors had to be balanced out against other types of claims in a broader settlement. And again, if we go back to the UK-Russia example, if that settlement had only focused on the interests of investors, then the legitimate claims of the Russian government would not have been dealt with in the way that it ultimately was. So there's a political question there about who stands to gain from different forms of claim settlement when the home state is involved or it's not involved. And finally, there's a question, I guess, for the lawyers in the virtual room, and that is, given the rise of investment treaty arbitration, to what extent is it even possible today, or should it be possible for home states to step in and settle or waive or modify property claims that are covered by investment treaties? I'll stop here, and I look very much forward to the comments, and thanks again for joining today's discussion.
Great. Thanks a lot, Lauge, also for keeping the time fantastically. Joost, I turn over to you.
Thank you, Anne, and thank you, Lauge. Can you all hear me well, I hope? Good. One thing that Anne forgot to mention is that I'm on sabbatical and I actually am deeply involved in creating a new law firm in Brussels. So it's been a very refreshing to read a historical paper like Lauge's, away from the day-to-day Trump tariff blasts and panicking that we experience in Brussels. But as Anne was saying, it is timely in that tells us a bit about the transactional nature of trade and investment these days, and looking back at history can be very revealing. I have 3 comments. One on definition, the second one on the goal of your paper, what do you really try to do? And then thirdly, on these hostages and market access, substantive points that you've mentioned. And then I'll say a word about your provocations, because I really do think they are provocations. So on definition, just so you are aware, for at least for me as an international lawyer, the notion of lump sum agreements was new. And I was looking, it took me a while to find the definition. And I guess you can define it the way you want, because I'm not sure whether there's a strict, clear lump sum agreements definition out there, which also creates the risk of some circularity, because depending on how you define it, you may highlight certain features or certain puzzles that you then try to answer, rather than more objectively looking at a phenomenon. So, for example, I'm much more familiar with the term settlements, and there's a lot of literature on settlements and the political nature of a settlement as opposed to an award. So you may want to build a little bit on this. But for example, you saying it has to be, the lump sum agreement has to be legally binding was a bit surprising to me. It needs to be government to government. I guess I can see that if it's more political. I can imagine you also have lump sum agreements between, say, Argentina and bondholders. They are different in nature, but are they really not a lump sum agreement? And then because sometimes you were saying a lump sum agreement could also be on a single claim or a single issue. And to me, the whole story you're telling, almost by definition, it's problems where you have a bargain happening between issues or a multiplicity of claims. So I was a little bit puzzled there as well as to whether it really could be one single claim on property taken, or wouldn't you expect at least several claims, or at least a dispute that is more than a pure expropriation? So that is just on definitions. I would define it up front. I was a bit lost in the beginning. Secondly, the goal. Clearly it's a fascinating topic, and you got my attention, and the historical aspects are really intriguing. But I was torn between looking at this as a historical description of things that happened and trying to explain why they happened and what is their nature and are they successful or not, as opposed to, are you trying to make an analogy, or are you trying to draw lessons from what happened in those days for what is happening today? And you threw in little nuggets trying to do the latter, but I think substantively, most of the paper is still the former, just a historical description of things happening. And obviously, what would make it really, really attractive is if you can elaborate a bit more on this pendulum, where I think you're onto something, that we are moving away from adjudication to more transactional settlements. Whether this is a good thing or a bad thing is something else. But I think it could be interesting to put that analogy or to further elaborate on that. Also in trade, you have, and I think in investment as well, hugely complicated awards that are then difficult to enforce, especially on trade. This premium you put on correctness rather than, expediency and pragmatism. So I think there's a lot to say for more politics involved and more settlements and more pragmatism, but it's a pendulum, right? So we went from little adjudication to then extreme complexity, legalization. We're moving away from it. But then looking at these lump sum agreements that you've mentioned, to me, that's already on the other side of the pendulum, where individual rights, justice is secondary, if not at the very bottom of the agenda. So in terms of the goal, I think you'll have to choose. Either don't drop these analogies to today and make it a historical paper trying to talk about why did they arise, these lump sum agreements, were they successful, variation, explanations, what have you. Or, and I think that would be way more challenging but also interesting, make analogies to what's happening today or could be happening, and trying to explain these things. Quickly on the whole story of hostages and market access, I find fascinating. Certainly hostages, because in these lump sum agreements, it's, if I understand it correctly, it's the defendant, say Russia, that has an asset in the claimant country, the US, right? And in the context of the Russian Revolution. Whereas in investment disputes, it's often the claimant, say Exxon, that has assets, a sunk investment in the defendant, say Venezuela. But then when enforcement comes, Exxon will try to enforce, trying to find assets of Venezuela and the US. So similarly in trade, you have this concept of hostages is playing a huge role. Like when the EU is thinking of imposing countervailing duties on electric vehicles from China, a big issue is, well, but China may hit back at the investments of BASF or Mercedes or BMW in China. Same thing with the EU-US trade war that is coming up. You have hostages, Facebook, all of these, Google, they are hostages in Europe. We can hit them back through competition law, Digital Services Act, what have you, whereas the US has all of us hostage given the financial supremacy of the dollar. So I think that idea is really interesting. On market access, same thing. If you make more analogies to investor-state dispute settlement, often you have two types of investors. The first type, they just want to get out of the country, get money, and often they will pursue ISDS to the death. Or you have investors who want to stay because they have sunk investments, and if anything, they would prefer to see a change in tariff, some subsidy, a different regulation, some preferential treatment. So again, these two notions, I think, can play a much bigger role. Now, I kept wondering, though, all of these examples of lump sum agreements are very unique, and they seem to be high politics clashes between countries that are at a very high level of animosity, right? So the Eastern, Western, whereas a lot of the ISDS cases today, it's, Swedish investors and so it's not really between countries that do not get along. So I wonder whether that would be a big difference if you want to make analogies to today. Finally, on your provocations, obviously, but that's what we academics have to do, and for most of the scholarship and history, we've been talking about, okay, we need to take power politics out of investment and trade relations and do it more rules-based. Of course, when you say, well, undercompensating foreign investors may be good for trade relations, from an economic point of view, you've mentioned it already. You would expect that if you undercompensate investors, that will increase risk, that will increase prices because these companies will charge more. That will reduce profits of these companies. So I'm not sure on an econ basis, even macro, whether it makes sense to say we need just high political settlements, lump sum agreements, and that will be better for all. I mean, at least for me as a lawyer, to go to that other extreme of just political settlements between countries with different power, it's the kind of thing that law by definition wants to fight against, right? But I agree that we may have reached the stage now where the pendulum is too much law, too much legalization, and we need to bring a little bit more politics into it. But to go back to these highly politicized, power-based lump sum agreements, I'm not sure you want to advocate that. I'll stop here.
Thanks, Joost. And I immediately turn to Geraldo. Go ahead, please.
Thank you so much, Anne. And I think I'll pick up where Joost left us, which is the power-based. And I always, recall this, and I should write this down before someone else takes, because I always say it out loud. There is something and that's something that this paper reminds me of, which is the Keynes piece on the economic consequences of the peace, which is precisely about how horrible it was that Germany was required to pay all of this compensation to other European powers and to others. for World War I damage, and that, as we know, it was part of the reason why Germany was in a crisis and couldn't let's say lift itself up, and partly behind the World War II upheaval. And Keynes says just in this, and he says, that lots of Germans say that the precedent established by the treaty, which is to put private property in the control of states that would be claimants, strikes a dangerous and immoral blow at the security of private property everywhere. And here's Keynes' comments. This is an exaggeration, and the sharp distinction approved by custom and convention during the past 2 centuries between the property and rights of a state and the property and rights of its nationals is an artificial one. And I think that's beautiful. And I think that's what you get at, right? So we're always interested in this distinction between flow and stock, and so investment is stock and trade is flow. But actually, the economy is circular, right? And then that's how how does one state protect property in another state, right? So other than by military means, and you're showing that that's how it plays out in practice in moments of upheaval. And I think that's something that I think I should be clear. I think that what seems to be the case here is that these changes happen in moments of upheaval when property rights become undone via the relations, lack of relations between states. Also, on the definitional part, I think there's a broader point, which is your paper is built as a historical paper, so it sort of goes on a crescendo, and then at the end you sort of throw a bomb and say, actually, in terms of investment law, we should think about all this. But let's say all the trajectory that gets us there is very much like, oh, I'm just looking at data, and I think that the argument should be put more clearly up front somehow. And on still the definition, yeah, exactly. So there's what you're looking at is, let's say, an unknown legal object, which also means that you're free to decide, right? So in terms of law, there's little difference between what you're looking at and, say, an agreement to terminate a WTO dispute by the payment of a lump sum to the other country where there are no claims. But you can just call these are intergovernmental agreements for the settlement of private claims. I think that's a perfect, let's say, that's in the sense that you don't need to, let's say, define this legally, because there's no specific legal consequence to this framing, but you can just cut it out and decide that that's what you're going to look at. And I think it's very interesting. Exactly. I urge everyone to take a look, because especially the information and the snippets you get are very, very good. In terms of comparison, before I go on about other things, so I think to have an oranges to oranges comparison, or apples to apples, if you wish, you need to. I think you need to look at not how much compensation was issued by the investment tribunals, but how much compensation was obtained by the investors, right? Because otherwise, you're comparing what is legally owed to in one case versus what was claimed to what was found to be legally owed in the other case. So I think that's, of course, another research project which you may or may not engage in. But the question, I think that's a very interesting thing, and it's something that I've been thinking about recently. How much of these investment claims get turned into actual compensation or actual recovered. The third point is, and I think you could highlight a bit, is this this exactly distinction between the transactional and the principled. And I think that the U.S. governmental agencies invoking repeatedly the principled. I don't know how much purchase that would have with the current U.S. administration. Say, well, does the U.S. believe that this is true, or as opposed to we just want to do this in this particular case? They may have seen that there's this Danish petition to buy California that is now gaining traction, has 200,000 signatures already. Or Danish people, let's say, pledge at least on the internet to buy California. So again, if of course this is not something that the administration implies, but they want to buy other territory, that someone else could also buy U.S. territory if they somehow manage to get the money. So again, this shows how transactional versus principled reasoning forms of reasoning work. What else? So yeah, but I think the interesting part that I think I would like to see highlighted, or maybe I should try to work on this myself, is this part on, you know, the how do states protect property when there isn't a, let's say, you know, or either they can't or they won't, or they think it's too complicated to mobilize traditional means, right? And so how does property get protected through not only through legal means but also through state action, and how diplomatic protection takes place in the absence of courts. In terms of the, you know, whether investment tribunals, again, I think there's a bit of this question, and this happens also in WTO law. There was, and I don't know if you may know this, but it's this discussion whether WTO remedies should be bigger or smaller, etc., to account for whether you want to punish non-compliance or whether you want. And one possible answer, and I think that the one that I would give, is that whether or not you believe that you know, these remedies should serve as a negotiating tool, that, let's say, it isn't necessarily connected to the size of the remedies, right? And I know that Joost has written on this, but I think, let's say, you can give an amount, telling, you know, on the understanding that this is what the law says, and the question is, in principle, let's say, it can be that the tribunal's objective is not to try to facilitate negotiations or create certain special rules that account for circumstances, but just to state what the law is, and that's what the parties paid for, were paid to do. And then the parties can subsequently negotiate. And I think let's say the additional element that you have in the ISDS is this ability, and then, yeah, of course, you notice with regard to the New York Convention, but the ICSID Convention says the same thing, that you have the ability to enforce this award anywhere in the world. And then you have this thing that I'm starting to look at, which is that you're starting to have third-party enforcement. So it's no longer, as the ICJ saying in, you know, 1948, that Albania owes Britain a certain amount, and then Britain can, like, 40 years later, pays this numerical amount, which is, of course, nothing compared, but at least that serves as what you call a focal point, right? So it says, okay, at least you paid something, and then we pretend that this all works out. But instead, what happens with the investment or awards, and I think this is not an issue about the award itself. It's about how the effects of the award has in domestic laws of, you know, Australia, United States, Switzerland, Sweden. Yes, I'll stop. And so I think that's something that I would look into, in the sense that it's not that you would then be able to enforce not your 50 million, but however many 50, 500, 1 billion it has become since then, once the statute is applied. Thank you so much.
Great, thank you, Geraldo. Now, would you like to answer, or would you prefer to take the questions?
I think I would prefer to just take this on the chin and open for questions. It would be great if there are others that want to chip in. That'd be great.
Yeah, because there are also great questions in the chat. So I start with the first one from SK Yildiz. So she says it's a very informative paper. Thanks. And she has two questions. First, the first is about the data set. Can you elaborate on your data collection process? What sources did you rely on? Do you consider this data set comprehensive, or are there agreements that remain undocumented? How do you account for informal settlements, agreements embedded with broader treaties, or cases where negotiations failed and left no formal record? Second question, you link some lump sum agreements to ongoing debates about war reparations. How do you see lump sum agreements being used in contemporary disputes, such as Russia's invasion of Ukraine? So this is a difficult one. You might want to... And then, again, from Mark Pollack, a suggestion. First of all, brilliant paper. And he says, far more interesting than the title suggested. So you should be changing to something like an alternative to ISDS, which would lead people to understand the potential relevance for the present day, in case you want to go this way. The substantive question builds on Joost's comment and has to do with the nature of the states most likely to engage in lump sum agreements in the 20th century, namely Eastern European states outside the emerging world, if ISDS. And thus he wonders if state-to-state lump sum agreements might be or become a live option in the future vis-à-vis host states that abandon their BITs. And you rightly make the point that investors with access to ISDS have little or no incentives to consider state-to-state lump sum agreements. I would say they don't lobby their governments for it. but made such agreements not become more likely between home states and ROC host states that are outside of the ISDS system. And then, okay.
Should I take some of those questions and maybe along in the same instance respond to a couple of the queries by Joost and Geraldo. So
Take
first of
all
all,
you
thank you.
want, and
Yeah.
if you have more time, I also have some questions. But
Okay, that's wonderful. Okay, great. So first of all, thank you to both to you, Mark, and to Geraldo and Joost for engaging with the paper and your productive suggestions and questions. I can't comment on all of them, but let me just pick on a couple. I think it's absolutely true, as Joost pointed out, that one of the challenges here is that there's no conceptual clarity. Often, what are we actually talking about when we're talking about a lump sum agreement? Now, there are some definitions in the literature that differ a little bit at the margins, but what I do in the beginning of the paper is to try and essentially flesh that out to be as clear as possible. And I think, I mean, you can tell me if I'm wrong. I think it's significantly clearer now than it was before I did that homework. And the reason I had to do that was because when you go and look at databases of treaties, you have to, in your Excel sheet, code, is this a lump sum agreement, yes or no? And that requires you to have a set of very clear criteria for what goes in that box and what doesn't. And so hopefully what's on those sort of 6 to 7 pages of fleshing that out is helpful and productive. But Joost is, of course, absolutely right. There's a whole series of lump sum agreements that are occasionally referred to as lump sum agreements that's not covered here, including amongst private parties. There's also agreements with intergovernmental organizations I haven't included. In traditional literature on lump sum agreements, and the main literature here is by Lillich and Weston. Lillich spent a large part of his career documenting and engaging on the phenomenon in this sort of from the late 60s and onwards. And they include agreements that deal with just a single claim, mining corporation claim, for instance, and in a couple of other instances. And many of the early agreements that we saw in sort of the first wave of what I call the first wave of lump sum agreements dealt with either a single or just a couple of claims, typically of named claimants. This could be a merchant or an individual. But as Joost also pointed out, that's typically not the case in the sort of post-war period, where we do tend to use the agreements much more for mass claims. But conceptually, at least in my treatment, as it has been in previous treatments of the phenomenon, it can be used as an instrument to settle a single claim, even if it is rare. And so the question sort of around, well, there was a sort of series of suggestions that were really, really helpful and productive, and I'll go and ponder them sort of in more detail. In terms of where I got all the information from, which is a valid question. So the database that I've compiled is based on the Consolidated Treaty Series database and the Peace Agreements database and the UN Treaty Series. And then I included country-specific compilations where they're available. I made inquiries with different archives and government departments, and also built off Lillich and Weston. Can I be sure that it includes all lump sum agreements? Absolutely not. But I think for the modern period, I'm reasonably certain, also given all the work done by Lillich and Weston, that very few would have been missed. I think the interesting question is for the earlier period, if we start scraping through agreements using various sort of modern techniques, I would think that we can reveal more treaties as lump sum agreements that I've found. But this is, again, one of the challenges of this, I think, of this work, is that the harder you start looking, the more agreements actually pop up, even based on the relatively limited criteria that I've used. Yeah. So Anna, so there were other questions. I can't. We only have sort of a couple of minutes left. So with apologies, I'll just sort of focus on that for now and then open up again if that's okay. Anna, you're muted, I think.
Sorry, I think the other question you might want to take is the one from Mark concerning concerns the future. I mean, a lot of questions are about the future. So concerning the wars, concerning the substitute for BITs, if there are none, especially for ROC host states, whether this would be an alternative for that. And I think what Mark questions hint at, where I would like to follow up is, if you go this direction, which Joost said concerning, what about the future? What's the role? What's the role concerning in relationship to IIAs? I guess you need to be very careful to make the distinction between single claims and, claims where we have mass expropriations, for example, or regulatory expropriations and stuff like that. And I think that you can already see, maybe, maybe you're able to see how many of the ISDS claims, and that we can see that, have this sort of mass character. Certainly the bondholder cases, but there might be others. And for those, lump sum agreements may be a substitution. For the others, it might not be. What I would like to ask you is, I also had a question about the definition, but I can do this bilaterally. Is the partial compensation? So what is, because you say in your paper you wanna answer the question of why, and so what is the partial compensation? What's the power behind the partial compensation and not the full compensation? Is this really only the lesson from the First World War, or is there something else behind? Can we somehow figure that out? And then from a political economy perspective, what I found is interesting is the frozen assets. It's not only a hostage, it's also playing to the internal audience of the host state, so the debtor state, because since a lot of them have been frozen for a long time, they're lost, right? So if the government says, we're going to get something in return, you put people in a gain frame, not in a loss frame, which is an interesting game which can be played from a political economy perspective. And then the last thing I would like to say, and that maybe that comes back to the partial compensation, if you look at the European Court of Human Rights, looking at the large-scale expropriations also in the Eastern European countries, they always went for less than the full market value. They said it's permissible in those circumstances that you pay less than the full market value. So they go very much, legally to what the lump sum agreements have done, because in large-scale expropriations, you are unable to pay the market value, basically. And in case you want to go to the future, I mean, what I thought is what Geraldo also said, and Joost as well, is the dollar dominance. Now, this is, of course, diminishing, and states, certainly after what has happened to the Russian assets, will get out of the dollar. So the power of the US, and it seems to me that they have been the main, in newer times, those doing the lump sum agreements, this power will diminish because they don't have the hostages anymore. So again, a question for the future. I stop here.
Yeah. So I think there's a whole series of questions circling around current relevance. I think from everyone. I saw another one in the chat also from
Karen. Yes.
From Karen on whether and to what extent the agreements can be an alternative to adjudication, given the types of issues that are covered and how they're covered. And I think a number of you also, Mark, sort of circle around this question around, well, what's really interesting here is why this tells us something about ongoing debates and why this tells us something about claim settlement in the age of Trump and so forth. And of course, I think that's true. And I think it's fair what Geraldo said, that I don't really deal with that in much detail. I sort of allude to it maybe strategically to get someone to read the paper, but I don't flesh it out. And I'm inclined, I think, not to do that for now, I have to say. I think there's and this is maybe my final provocation of the day, I think there's a sense in which a lot of international law scholarship on claims are obsessed about the present without having a particularly good understanding of the past. And what I think this project, along with other colleagues that are doing close archival work on claim settlement from a historical perspective, is essentially trying to revisit some of the arguments and claims that have been made, the descriptive claims that's been made, not normative, but descriptive claims that's been made about how claims were settled in the past, what was the role of politics, what was the role of law, what was the role of home states, and who won and who lost out in the process. And I think there's large-scale claims, as it were, made about those sort of processes, but actually quite limited, detailed empirical scholarship. And I think that's the starting point before we start engaging really on what a 1685 lump sum agreement can tell us for how we engage with Trump. And so I know that's sort of a bit of a fudge, but I do have a sense that large parts of the scholarship on the history of international economic law and claim settlement, maybe in particular, suffers from a lack of engagement with archives. And you have these sort of circular references within the literature without actual primary materials included in there. And I think there's value in it of itself to have a better understanding of how the most important instruments used to settle international claims in history, in particular during the 20th century, were in fact negotiated. And then there's a second question about what does that then mean for today? Whether that's going to help it get published, I don't know, but I think I'll sort of try and stick to my guns on that one. There's a whole series of questions here, and I appreciate we're running out of time. So what I might do, and with your permission, is I might reach out to those of you who have asked those questions and maybe continue the conversation bilaterally, if that's all right with you, because on my watch at least we only have about 90 seconds left.
Right. Thank you so much, Lauge. And again, thank you for presenting your work here, and to Joost and Geraldo for commenting on it. I think it was super interesting. And as you say, it's a start. We look forward to see the paper out at one point, and curious to see where you're going to turn. Before we stop, I would like to draw your attention, and also many thanks to the audience for asking the questions and listening. Before we stop, I would like to mention two things. One is this video is going to be available on the ASIL YouTube channel, as well as on the website of the ASIL IG. And I would like to draw your attention to the next talks of this joint series on February 26th by Veronika Fickfak on the Human Rights Bar, Lawyers at the European Court of Human Rights. On March 19th, by Guillermo Garcia Sanchez on the other secret deals, uncovering the power of non-binding international agreements. And on the 14th of May by Janina Dill and Marnie Howlett and Carl Müller-Crepon and Mara Refkin, Fate or Choice, Attitudes Towards Collaboration and Redemption in Ukraine. So thanks again to all of you, including the audience, wherever you are. I'm wishing you a wonderful day, evening, whatever, and see you hopefully soon in the next webinars. Thank you.